everyone to today's webinar. I'm Sierra Middleton, Marketing Manager. Estate Planning Demystified is about breaking through the confusion and complexity that often surrounds this important topic. At its core, estate planning is simply making clear, thoughtful decisions today to protect your loved ones, ensure your wishes are honored, and minimize burdens in the future. Without a plan, the courts, not you, decide how your assets are handled, which can lead to delays, extra costs, and even family conflict. By understanding the essentials, you can take control of your legacy and create a plan that's clear, effective, and truly your own. Before we get started, a few housekeeping items. This session is recorded and will be shared with all who've registered. If you have any questions, please send them in the Q&A box at the bottom of your screen, and we'll answer them throughout the session and at our Q&A block at the end. Now, to introduce our speakers today, we have Eric Dostal, a Managing Director and Financial Advisor at WealthSpire Advisors, based in New York. He helps his clients manage their wealth and focus on investment, insurance, retirement, and tax planning strategies, and recently launched a video series, Navigating Estate Administration. Khadija Honeybrooks is a Senior Vice President and Director of Wealth Strategy in Wealth and Tax Planning, based in California. She's a key member of our family office service team and works with ultra high net worth clients and their advisors to identify complex estate, tax, and wealth transfer strategies. And now I'm going to pass it over to Khadija to take us away.
Thanks, Sierra. Welcome, everyone. Eric and I are so happy that you're here to join us. I'm just going to do a quick table of contents agenda for you. So we're going to kind of go over the basics of estate planning. We'll talk about some myths and mistakes, go through what is a trust and how to set one up, and then how to integrate your full estate plan with your team of financial advisors. We'll go over some key takeaways, and then we'll have an opportunity for Q&A. So if you have any questions, please put them in the chat, and we'll try to get to them at the end. Go for it, Eric.
Perfect, thanks. So to start off, we just wanted to talk about kind of like the who, the what, the why, the where, the when, all those major questions, starting with why do estate planning at all? And it's really about making sure that what you want to have happen does happen. And so by default, every state has a plan for people who decide not to create an estate plan themselves. And it's typically called intestacy. And what it means is there is a plan depending on where you live, what would happen with all of your assets if you were to pass away. And that might not be what you want. And I think a great example of that is drawing from New York. If you were to pass away and married and have children, under New York's intestacy law, part of your estate would flow to your spouse, which is probably what it is that you want to happen. But a part of your estate would also flow directly to your children. And oftentimes people aren't ready to make that type of transfer until both spouses pass away. But that's up to you to decide. And that's the great thing about estate planning is it lets you to kind of think about and dictate where those assets are going to flow. It gives you this opportunity to think critically about if there are specific people outside of your immediate family that you would want to support or charitable causes. You can bring those into the conversation at that time as well. And it's really about making things easier for those that are left behind. Oftentimes, the estate planning work that we're doing is not so much only about the individual who is going to pass away, but to make things easier for their families and the people that they care about. And that's a really, really big reason behind the why. Other types of things that come up often are if you're in a blended family situation. So second marriage, maybe for one or both spouses, previous children from other marriages, other considerations. Those don't very neatly fall into some of the defaults that come into play for estate planning generally across the country. And that's a really, really good reason why you want to take the time to sit down and start thinking critically about what you want to get out of your estate plan. And Khadija, I think this is a good opportunity to kind of touch on potential community property considerations that come in as well.
Sure, definitely. So I live in California, which is a community property state. There are a few other states throughout the country that are also community property states. If you're not sure if you live in one, we can discuss that later. But basically, community property states work a little bit differently than the rest of the country. because we have rules here in California that specify whether or not you own assets with your spouse or on your own. So here in California, we have what's called community property, which is anything that is acquired, with some exceptions, during a marriage. Essentially, the way we look at it here is that for every dollar that is earned in my marriage, both me and my spouse own 50% of it. And it's not 50 cents and 50 cents, it's like 50% of the whole. And then there's separate property, which is anything that you had coming into the marriage, and then certain things that you acquire during your marriage, for example, inheritances. But these rules can get really complicated, so it's especially important to do some estate planning if you live in one of these states.
Yeah, and I think the only thing I would add is it also depends on the time that you acquired these properties. So let's say, you started your marriage in California and you lived there for some period of time, but then you moved to New York or New Jersey or any other state. You could have a mixture of both community property and non-community property. And just unraveling that is really, really important. And that's a great reason why you have an estate plan. The other thing that just came to mind, which isn't necessarily here, is sometimes we're planning for things that don't necessarily equate directly with passing away. So it could be disability planning, or you want to make sure that your wishes would be honored in a medical emergency situation. Those are all things you could do through your estate plan and why it's important. And I think that kind of moves us to our next slide.
Great. So you might be wondering, what does this mean, my estate? So we use a lot of words that can be confusing if you've never heard them before. Generally speaking, sometimes we will say your estate, which just kind of means everything you own. But there are some real technical legal terms as well. So, for example, your probate estate is any assets that you own at death that are going to go through the probate court. So that includes assets that are directed through your will, and assets like Eric was mentioning that are going to go through intestacy, meaning you don't have a will, you don't have a plan at all. So the court is going to decide. So that's your probate estate because it's going to go through probate or through the probate court. Then there's your non-probate estate, which is going to be any assets that are going to pass outside of probate. So let's just say all you have is a will and you're going to for sure go through probate. There still could be some assets that aren't going to be included in that probate estate, and those will include things, any assets that transfer directly to someone else, so directly from me to a beneficiary. Those can include things like retirement accounts where I have a beneficiary designation, an account where maybe I have a pay on death account or a transfer on death account. So those go by beneficiary designation and won't go through probate. Another term we use is your taxable estate. So we're not going to get too into the weeds of estate taxes during this presentation, but just to give you a very broad overview, everyone has a certain amount that they can pass to others other than their spouse during life or at death before there's a tax that's levied on that. You may have heard about estate taxes, estate tax exemption. So that's kind of the world we're talking about right now. Now, that amount is the highest it's ever been. It's almost $15 million per person, 30 million for a married couple. So in order to figure out kind of where you fall, are you over that amount, meaning you will potentially be subject to an estate tax? Are you under that amount, meaning this isn't something that you have to worry about? The IRS and really your lawyer before that, hopefully, will help to calculate what's the total amount that is going to be subject to estate tax. And again, if you're married and you're under 30 million, this is not something that you have to worry about. And if you have over that, then it is something that you will worry about. So that's your taxable estate. Then another term we often use, of course, is a trust. We're going to talk a little bit later about what a trust is, how to create it, and some of the pitfalls in creating, not creating one. Important to remember is that a trust and a will are two different things. Now, this is where things get really complicated because sometimes a will can create a trust. But when you're thinking about them, I think it's helpful to think about two different things. We have a will, which is a written document that helps your executor figure out maybe the guardians of your children, where you want things to go. A trust is, I like to think about, is kind of like a box. It is a written document that creates a box and then you put stuff into it. So, what are the kinds of things that can go into it? Really, everything, anything. So, you can put jewelry, tangible personal property. You can put your investment accounts, your brokerage accounts. You can put real estate, whether it's your, personal home, investment properties. You can put a business. You could put a car. We don't normally see that, but if you are a car collector, I've had clients who have millions of dollars worth of cars. Maybe you want to put that in your trust. So really, almost anything can go inside of a trust. So we talked again about kind of the different types of documents. So we have a will and a trust, which we just talked about, and you'll remember now forever that those are two different things. We also have a POA and a TOD. And in this world, we love our acronyms. So a power of attorney. We have powers of attorney for financial documents, which basically means if you are incapacitated, someone else can step in and make financial decisions for you. Typically, we see that's a spouse if you're married. It can be a good friend, it can be your attorney or your CPA. If you have adult children who are responsible enough, it can be your children. And then we have a TOD, which is a transfer on death. You'll remember I mentioned that when we were talking about the probate versus non-probate assets. A transfer on death is a document that says automatically when I die, X thing goes to this person. So depending on the state that you live in, depending on the assets that you have, you might need a will, you might need a will and a trust, you might need a will and a trust or a TOD, and you probably always will need a POA. So kind of confusing, but when you talk to an estate planning attorney, they will help kind of guide you through all of these. And the final document I'm going to talk about here is a letter of wishes. And Eric and I have talked a lot about this. It's something that we both really like to see. When you write your trust, you will give some instructions for your trustee on how to distribute your assets. Maybe at the second death, you've decided to create some trust for your children, how to distribute those assets to your children, etc. These are legal documents. So they really kind of provide like some legal guidance, but we have found it's really helpful to give more of that like personal touch, right, Eric? That kind of the guidance that if you were sitting down, if I make Eric my trustee, and he's just reading a document. That's different than me giving him a letter that says, Eric, you know me and my spouse, you know how we've raised our kids, you know what our family values are. We want our kids to work hard, but we want them to also, have fun and enjoy life. And we don't want them to be spoiled, but we've worked hard so that they can have a nice life too. And, so it's kind of a little bit more conversational. It's not a legal agreement, but they're really, really helpful. So this is something that we've seen a lot more of recently and that I really encourage clients to work on.
Yeah, no, definitely. And I think, you made up a great point is that legal documents are written a very specific way. A lot
Mhm.
of people refer to it as legalese, because because they have to do very, very specific things and be done in a specific way. A letter of wishes gives you the freedom as the creator of your estate to really talk about what it is that you want to have happen in your own words. And that can be a really, really powerful tool for a future trustee or even your future beneficiaries. So they just kind of understand a little bit more of what you were thinking about. And so that's a really, really big thing that we've been talking with a lot of people about is thinking about writing and producing that letter of wishes along with their estate plan.
Yep.
Yeah. The only other thing I'd add, just
Oh,
in terms
sure.
of everything that we went over here, I think a lot of people can sometimes get tripped up by when we say my estate. Like you said,
Mm-hmm.
you could have a trust that you created that is revocable, and we'll get into that in a minute, but it's the idea of like that is in your taxable estate, the assets that you have in that revocable trust, but it's not your probate estate. But
Right.
we're referring to the whole thing as an estate, and I think that can get a little tricky for people sometimes, for sure.
Yeah, definitely. Thanks for clarifying that. It's very true. It's really confusing, and you can thank us lawyers for that. So sorry.
Sorry about that. All right, perfect. So I think the next piece to kind of jump in is who are we talking about when we're creating a plan? And there are a lot of very specific names that get tied to very specific jobs when you talk about the creation of an estate plan. So one of the big ones right there at the top is a trustee. And the way to think about a trustee is it's somebody who has all of the responsibility of ownership, but none of the benefit. That's the way I typically talk about it. It's their job to make sure that the asset is protected, that the asset is growing or doing what it's supposed to do inside of the trust. But all of the benefit of that growth and appreciation and value doesn't belong to the trustee. That flows to the person that ultimately is going to get that asset or benefit from it, your beneficiary. And that's a really, really important relationship, especially when we talk about in this kind of estate planning context. We're really thinking about people who are going to step in after the person who has created the plan, has kind of created that initial family wealth, is no longer with us. And they're going to be responsible for making sure that that person's wishes are met. Oftentimes that can be, a really close family friend or other family member can serve that role. Sometimes it's a trusted advisor, whether that's an attorney or an accountant or somebody like that. Sometimes it can be a professional trust company that's their job is to step in and make sure that those roles, that your wishes are being fulfilled. But that is ultimately the job of the trustee. And it is a job. It's something that needs to be done and taken seriously because there are a lot of legal kind of constraints that go along with it, a lot of requirements that you need to meet as a trustee. And it's something to be taken very, very seriously that lasts a really, really long time normally, depending on the terms of the trust. But normally it's a longer appointment. I say that to contrast it with the next one that's listed there, which is your executor. That is still a very important role. It's something that is also a job and needs to be taken very seriously, but it's for a finite period of time. An executor's role is simply to marshal the assets of a decedent, figure out where everything is, kind of bring it all together in one place, gather those assets, protect them during the time period that the estate is open, and distribute them according to the terms of the will. That is an executor's sole job, and hope that's all that they're responsible for. So again, extremely important and needs to be taken very seriously, but it's a much more limited in time appointment as opposed to a trustee.
Can I jump in for
Beneficial,
a second on that too,
yeah, of
Eric?
course, of course.
Yeah, just to add, for example, in California, most of our clients here have what we call a pour over will.
Mhm.
So all their will says is whatever I own, just pour it over into my trust. And really, in those situations, the executor is kind of meaningless because then the responsibility shifts over to the trustee. So just for those of you who are in California and some other states might be the same, you might have thought, oh, I haven't really seen an executor. We see them a little bit less here because we're very, very trust heavy in California.
Yeah, no, definitely. And I think even in jurisdictions, I'm out of New York in the Northeast, seeing a pour over will is very, very common, where somebody has created a revocable trust and all their will does is the exact same thing. It says, whoever my executor is, you gather my assets and you pour them, hence the name, into my revocable trust, and then you've satisfied your duty. That's all you need to do, executor.
Yep.
So it can be like that for sure. Yeah. Beneficiaries, I think we touched on briefly, but it's really the people that ultimately are going to benefit from your assets. So that could be something like the beneficiary of an IRA account. They're listed. They get those assets, the IRA assets, outright when you pass away, as opposed to the beneficiary of a trust, which might last for that person's lifetime or until their set age 35, or there are many, many different flavors. But ultimately, that's what a beneficiary means. Guardians typically come up in a minor situation. So if you have a beneficiary who is a minor and who's going to inherit assets, they'll probably would need both a guardian of the person that's going to take care of them until they reach age 18 or the age of majority in your state. And then there's also guardians just in terms of who's looking after their assets, like a custodian or something like that. In the estate planning context, there are instances where it's an adult who needs a guardian. And then it kind of depends on how that person's appointed. That might involve a court proceeding where somebody has been brought to the court and the determination's been made that they need somebody to step in and help them manage their affairs. And then you could have a guardian of an adult in that situation as well. And then there are advisors. Obviously you have your financial advisors who come in and kind of help navigate all of this, but you have attorneys, you have accountants, you have real estate agents, insurance brokers. There are a lot of people who kind of step in and help through the estate planning phase and the administration of it. And it's really, really important to kind of understand the who does what. Yeah, I think those are a lot of the who. Deidre, anybody else that you?
No, I think you got them all.
Okay, awesome. And then when, so I think we had approached this idea in a couple of different ways. The timing of when you should put an estate plan together is, if you don't have one now, do it now, please, right now, or at least right after this
leave
call.
this webinar right now. And
but yeah, there is no magic time. There is no perfect time. If you do not have these estate planning documents in place, by that we mean the will we talked about, potentially a revocable trust or some other trust structure, the durable power of attorney, a healthcare proxy, or living will. Those are what are typically referred to as the main estate documents. If you do not have those at all, now is the best time to get them. If you already have them, on average, we talk about reviewing them either every 5 years or so. That's just a good time to just double check, make sure everybody you've named is still in a good place and things like that. Or major life events. Somebody's been born, somebody passed away, there's been a marriage, like something in your life has really changed. That normally also warrants an estate plan review. And oftentimes nothing needs to happen. There doesn't need to be an update, nothing, everything is fine, and we can keep going. But checking it within those timeframes is really, really important, because your circumstances change, your thoughts change, the law can change. These things are kind of living and evolving as we move through life.
Yeah, definitely. I mean, I think in terms of the circumstances too, we have a lot of clients who have sold a business. They've had a liquidity event. So their plan made sense when they had $1 million, $2 million. Now they have 20, 30, 50. You might want to, change something. So that's another kind of good life event to take a check. Ideally, if you have a business and you're going to sell it, you talk to your estate planning attorney and your financial advisor well before you sell, so that we can engage in some planning around that. But in the event that you haven't, at least you want to relook at your revocable trust. So let's talk about a couple of mistakes and myths. So I've been doing this work for about 15 years, and I talk about death all the time. But I know most people don't talk about death all the time. And I know that for a lot of people, it can be really hard to sit down and think about your own mortality, your end of life, leaving your spouse and your children behind. The problem is, if you ignore your estate plan, it doesn't make you immortal. We've seen thousands of times before. It's not the key. Sorry. So one real myth is, if I just ignore this, I'll never have to worry about it. And unfortunately, like Eric was saying in the beginning, what that does is it could potentially leave your family, your loved ones in a situation where they're having to make a lot of decisions and clean a lot of things up when they're grieving. And so it's really a gift to your family, to your loved ones, to spend some time, I'm not saying every single day, but to sit down. If you're watching this webinar right now and you don't have a plan, maybe it's time to think about it. If you're sitting with your spouse watching this, maybe take a few minutes and say, hey, what do we want this to look like? I want you to make sure you're taken care of. I want to make sure the kids are taken care of, etc. So, Eric and I really want to remind you that this is important to do. And unfortunately, it, it, it will come up at some point.
Mhm.
Um, so the next sort of myth and mistake that we see a lot is I don't want to create my plan because something's going to change. Okay. Why would I write my plan now when I know that in 6 months I'm going to meet the love of my life and get married? Or or the opposite or something. Well, almost all of the documents that we've talked about today, other than kind of referencing a little bit of more irrevocable trusts, everything can be changed. Okay. Your will can be changed. Your revocable trust can be completely revoked, amended, restated, rewritten. Um, so make the plan that works for you today. And if something changes, you can come back and address it. Okay.
Mhm.
But just to sort of, again, I don't need to worry about it because I plan on getting married and having kids, sometime down the line. Well, sometime down the line, you can change your plan. And today would be a great day to at least get something down.
Yeah, and Khadija, I'll just jump in real
Please
quick there
do.
too. Sometimes I often see clients who are, they're getting their estate plan done, it's great. But then suddenly the question comes up, well, if both of you pass away, who's going to take over caring for the kids? And suddenly everything comes to a screeching halt. And
Yep.
it's a really hard question to answer. And you think, well, maybe my parents, but then they might get older, so I don't know.
Mm-hmm.
But then your brother, he's got that real girlfriend right now. I don't know how I feel about that. You know, I think that idea, you pick who makes sense today, and then you can kind of go with it, and you can always change that in the future. Don't
Absolutely.
create impediments to yourselves to finalizing these documents because, again, like Khadija, like you just said, they can always be changed and adjusted in
Mm-hmm.
the future.
That's exactly right.
Yeah.
That's why I just put my best friend as the guardian of my child. And I didn't even tell her. I just said, well, if I have to change it, I'll change it. I don't advise you do that, but um, okay, so the next one is I'll just deal with probate. It's not that bad. I'll just what Eric's described before. I'll just go by whatever that intestacy thing is. It can't be that bad. Um, Now, sometimes that might be true. Maybe, like Eric was explaining in New York, we have a very similar system here in California. If you die without a plan at all, you die intestate, and you have a spouse and a couple of kids, all of your probate assets will be split. There's some nuance with the community separate property, but will be split between your spouse and your kids. And it can be a third to your spouse and two-thirds to your kids. And like Eric was saying, generally we don't see parents wanting their kids to get that much at the first death if your spouse is still alive. So, first of all, intestacy probably might not work for you. Um, Now, thinking about if you just have a will and no trust, and you say, well, um, I'm not going to be intestate, I have a will, I just don't want to deal with doing a trust. In some states, that's perfectly fine. We see a lot of clients in a lot of states who only have a will and that works for them because the probate process in their state is pretty seamless. It's quick, um, it moves quickly, it's not that expensive. There are some states like California where probate is a pretty big pain and you really do want to try to avoid it. Um, it can take a long time. It can be very expensive. Um, and it's public. So all of your assets, all of your information, all your business is going to be in these court documents. And I don't know any of you listening, but I'm assuming you probably don't want that. Now, if you do, okay, but be warned. And the last myth or mistake we see is once I draft my trust, I'm totally done. And now everything goes from my probate estate into my trust. And that's not true. Unfortunately, after your whole estate plan is done, there's still a little bit of work that needs to be done, particularly funding your revocable trust. So if I have everything in my name and I spend all this time writing this beautiful revocable trust, I have to transfer the stuff from my name into the trust. And if I don't do that, I could kind of be in trouble.
Yeah, no, definitely. And I think sometimes that very similar to that, what can happen is somebody spends a lot of time and effort and money, to be fair, putting together an estate plan that does all of these great things and it makes very specific requests to people and sends them funds. And then they go and time passes and they kind of forget about it a little bit. And then they title all of their assets with transfer on death designations, or they transfer them as joint tenants with rights of survivorship with their spouse or somebody else. And what can happen is, depending on how you list assets and how you name beneficiaries, you could be circumventing all of the estate planning work that you've done. And that gets back to kind of what we were talking about before. It's just really important to understand how the mechanics of that work and what does that really mean if you're trying to maybe avoid probate, which sounds like a really good thing. So it's like, oh, I'll just put beneficiaries in all my accounts. That's fine if ultimately that's what you want to happen, is everything just pass outright to whoever you're naming. But that might not be what's in your estate plan. So it's always good just to understand that when you're putting those types of things together.
Definitely.
Yeah.
So moving on, I'm going to talk briefly just about setting up a trust. So the process will vary, of course, by your state, by your attorney, but overall, you will reach out to an attorney. We have lots of referrals. We work with a lot of incredible attorneys, and you'll sit down. Often they'll have a questionnaire for you, which is kind of gathering information about your family, your finances. This can be a little bit difficult because you have to disclose basically everything. You have to talk about your family, your children, your secret children. You have to talk about your assets, how much money you have, how much your net worth is. And these topics can be really uncomfortable, but they are important. And it's really important that you find an attorney who you trust and who you feel comfortable having these conversations with. From there, they generally will provide you a draft within several weeks. It can take a couple of weeks for them to get ready. You'll review that draft, make any changes you want, and then you'll sign. The whole process, really, I've seen it take a month. I've seen it take 18 months because people are, especially like Eric said, you get to the point where you're guardians and people say, oh, I don't know, or just again, remember all of this can be changed, and you're planning for today. Now, in terms of cost, Eric and I talked a lot about this. Do we want to say an average? Do we want to say, and we're not going to, because it really, really, really depends. It depends where you are. It depends on the complexity of your family. A lot of people say, well, I don't think I'm that complex. But I've been married 4 times. I have 7 kids with 4 different people, and I just inherited a bunch of money. And then I started this business with my ex-spouse. You know what I mean? So in that situation, that's going to take more time. So some attorneys will charge you by the hour. Some attorneys will give you a flat fee. Sometimes people look at the cost and say, no, thank you, which I understand because we're talking thousands of dollars. And that can put people off, but I think it's worth it. Eric, I know thinks it's worth it. And we've mentioned before kind of that this is a gift to your friends and your family and your loved ones. And it's really worth it to spend some money up front because if you don't, your family's going to be spending much more on the back end, plus dealing with all of the emotional stuff that we've talked about. So, as hard as it can be to swallow the pill of the cost, it really is worth it.
Yeah.
Um, and then again, we talked about the timing of kind of how long it can take. Usually the client is kind of steering that. So I recommend, like I said before, sitting down and really thinking about some of these questions so that when you go to an attorney, you're ready. When they say, who do you want to be guardians of your minor children? You're not thinking about that for the first time and saying, oh gosh, my spouse and I need to go spend a couple months thinking about that because you've already done it. And then Eric can tell us how can an advisor help do this with an attorney and with a client together?
Yeah, so I think it's always really, really good to start with what we don't do and what we can't do. So, as Khadidra mentioned, both of us are attorneys, but we're not practicing attorneys. We're not sitting here drafting your documents and giving you legal opinions about things. But one of the great things is that we are love to collaborate with your attorney, with your accountant, really understanding and being a translator. So a translator means, we're taking in all the information that's tied to your family, to what we learned about you as being a financial advisor, taking and thinking about your long-term planning needs and what it is that you hold valuable and hope to accomplish over time, and communicating that to your attorney in a way that clicks for them. It's like, oh yeah, like pour over will, AB trust structure, yada yada, blah 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 blah. That's our job, is to kind of step in and block a little bit of that jargon and legalese, and also translate it back so that you feel like you completely understand the mechanics of what is going into your estate plan, how it would work under different scenarios, and guide you and make you feel really comfortable that ultimately your needs are being met and what you want to accomplish with your plan is being done. And then also there's a mechanical piece of it that comes into play too. Obviously, we spend a long time thinking about, if we did create that revocable trust, we need to retitle assets into it. So what are we going to move? How are we going to change your beneficiary designations of retirement accounts to make sure it's going to flow to the right people? Do you have your agent for your durable power of attorney listed on your accounts, at your custodian, at Schwab, at Fidelity, at the bank? You don't want to be in a situation where somebody becomes incapacitated and you're fighting with a back office at a bank to try to get some money out of their account. Those are the real things that we bring to play when it's time to implement that estate plan. And then also we'll remind you regularly to revisit it, remind you what's in there, comes up regularly when we talk through our planning meetings. But that's our goal, is to translate between the experts, the attorneys, and everybody who's drafting, and what it really means to you as the client. Yeah. And so with that, I will shamelessly plug my administration guide. So I've been working through, we have about 4 episodes right now, just some thoughts about the estates that I've helped administer through my time as here at Wellspire, as well as kind of a little bit of some of the things I picked up having personally administered the estate of my aunt, and just some insights that I've been sharing with people about how we can make this process a little bit easier for everybody, and help through what is a really, really difficult time in a family's journey.
Thanks, Eric.
Yeah. So with that, I think we can open it up to some questions. I know we have some come in, so yeah, let's jump in.
Yeah, hey Eric and Khadidra, I'm back. We've gotten quite the array of questions. I'm
Great.
not sure that we'll have time to get through all of them, but we will follow up with those of you who we don't get to, of course. But to kick it off, I think let's start with, what are some important considerations for estate planning for those without spouses or children?
That is a great question. And I think the way I approach it typically with a client is to ask, is there a more remote family member that you feel close enough to that you would ultimately want to help out and benefit? And that's a very personal decision. And the answer could be yes, and in which case that would then be your heirs, and we can figure things out that way. Or the answer could be no, and there's not really any more remote family member that you particularly feel close to. or that you think needs the dollars that you have. In which case, the beneficiary is a charity. I mean, that's really the last kind of place for an estate to go, other than the government. And oddly enough, most people don't want to just send their money to the government. Not quite sure why. Um, but then it becomes a really fun exercise in thinking about, what causes do you find really meaningful to yourself personally? How would you like to benefit those over time? And how can we structure that in a way that's really meaningful to you?
Yeah, I completely agree. And to add to that, there are a couple ways if you are in a situation where you would like for everything to go to charity, there are a couple of ways to structure that. My personal preference is to create a donor advised fund, and just to say everything goes to your donor advised fund and give some directions to whomever is going to administer those funds of what the causes are that you believe in. Um, you can also just list charities in your documents. Um, that for me is a little bit more difficult because if you want to change that, you have to go through a full amendment of your trust or your will. And if you're just saying, oh, I used to want 10% here, now I want 20%, doesn't necessarily need to require an attorney visit. So I'm part and partial. I don't know, Eric, if you have an opinion, but that's just where I like to try to steer clients.
Yeah, no, I think that that's a great idea. And it does give a lot of flexibility because you can change those designations to the donor advised fund at any time. And
Hmm.
it's just a simple form that we can help fill out and submit to the
Yeah.
custodian on your behalf. So that makes a ton of sense to me.
Yeah, great question, great answers. Moving a little bit as well, what stage in life should someone start thinking about setting up a trust?
Well, if you'll remember, Eric, what Eric said, I think it was now. Did you
Now,
say?
I did
Now.
say
Okay.
now. I said now.
Okay, great. Now.
Reiterating, we love it.
No, I will. So, if someone is on here right now who's, 18, 19 years old, you know, okay, we could take a look at the assets and figure that out. There is no specific age, but I do say a lot of people do really jump into estate planning when there are children involved.
Hmm.
When there is the next generation behind them, that's really the main impetus to put all these things together. And at that point where you're really putting an estate plan together, a trust can make a ton of sense for all the reasons that we.
Absolutely.
Sure. Yeah, to building on that as well, and you touched a little bit on this, but what would you say the difference between a trust and a revocable trust is?
Oh, great question. So, there are lots of different kinds of trusts. Um, they can do a lot of different things. They can hold your real property, they can hold insurance policies, they can hold your business. But all trusts fall into one of two categories. They are either revocable or they are irrevocable. So if you kind of think about like a tree, at the top, we've got the box of here's trusts. And then the next is down, is it a revocable or an irrevocable? Revocable means that you can change it at any time. You can cancel it. You can amend it. You're really in charge. You can do whatever you want. Irrevocable is the opposite. So once you write it and you sign it, it's pretty much set. Of course, as lawyers, we love exceptions. So I'm guessing that's why you're smiling, Eric, because
Mhm.
we always have an exception and an exception to an exception. There are ways to change irrevocable trusts. They can be anywhere from getting all the beneficiaries and everyone to agree to going to court, but they require more than a lot more than a revocable trust. A revocable trust, my spouse and I have one, and if we want to change it tomorrow, we can change it. Our lawyer will do it. Well, I suppose I could do it because I am a lawyer, but our lawyer would do it. But irrevocable, much, much, much harder. An irrevocable trust really we see for a variety of things. Like I said, they can hold businesses, especially if you're going to have a liquidity event. Um, they can, if you pick the right jurisdiction or the right state to put them in, they can go on and on forever and ever. So lots of flexibility with both, but ultimately that's the big difference.
And the only thing I would add on there is this is also where that concept comes back in when we talked about things like the the probate estate versus the taxable estate versus, my estate generally. This
Mhm.
is where some of those distinctions can come in, because an asset that you're holding in your revocable trust would be outside of your probate estate, but included in your taxable estate. And oftentimes that's where the planning opportunities come in with irrevocable trust, because it gets you that asset not only outside of your probate estate, but outside of your taxable estate as well.
Great point.
Yeah, I think that's great. This next question I think probably comes down to some personal decisions as well. But how do the two of you feel about the trustee, the executor, and the financial POA being the same person?
I love it. I think it makes things easy. If you have one person who you trust for all of those roles, I think it can be really help things be more convenient because they don't have to all try to talk to each other. It's just the same person that kind of says, okay, I'm going to put on my trustee hat, I'm going to put on my executor hat. A lot of the functions are the same. If you'll remember what Eric was talking about, the executor marshals the assets, gathers everything. That's what a trustee also does. So I think it's a great idea.
Yeah, I agree. And I think we see it a ton, especially where, there are two spouses, everyone's alive, they each name each other as the trustee and the executor and the power of attorney and all of the things for each other. Sometimes it gets difficult when that first spouse passes away. And now the survivor needs to really think about and make that decision. And sometimes it's really easy. And it's, my daughter is perfect for everything and she can step into that role now. Sometimes, different people, my daughter would be great as my trustee, but my son would really be better as my, healthcare proxy because
Hmm.
he's a doctor or what have you.
Yep.
That's where we see sometimes where different people for different roles can make a much bigger impact.
Awesome. I have one more question that I think is very topical, very timely in 2025. Of course, as AI is everywhere. How can you use AI, or what are good ways to use AI to maybe help you set up a trust or planning documents? Can you use AI and then take it to a lawyer? How does that process work?
So I think AI would be a great tool to do some initial research into everything that we've talked about today to get some ideas about what's potentially possible. The thing I will caution everyone about is ultimately you're going to want an attorney who is licensed and specializing in your particular state, your jurisdiction, to ultimately say what does and doesn't make sense for you. Because I think AI is a wonderful tool. I use it all the time. It's really,
Hmm.
really cool. I would never in a million years create my estate plan using ChatGPT or something like that and feel okay about it. Just because that's not really what it's made for. It shouldn't be used to create legal documents like that.
Yeah, I completely agree. And just a couple of other points. If you try to have AI draft a trust and then you want to take it to a lawyer, they won't use that. They're going to start from scratch. So it really won't be helpful. It's kind of the same idea. Eric and I also talked a lot about how we feel about some of the online platforms that can draft documents. And I think there are some incredible programs out there, but ultimately, call me old school, sitting down with an attorney in your state, who you're meeting, um, is the best way to do things. In addition to what Eric said about using AI, I think it could be a good tool to help with maybe the letter of wishes or kind of
Mm.
thinking about maybe, to the person who was saying they're not married, no kids, maybe AI could be a good place for you to start. I'm not married, I have no kids, I have X dollars. I don't know what to do with them. And how do I decide? I think that could be a great way. ChatGPT can sort of maybe help you flesh out some causes that might be helpful to you. So sort of the ideas phase, but not the drafting phase.
Awesome. I think those are some great thoughts. Again, some very timely questions. Um, I think we are at the end of our program, so I do want to note that for those that we did not get to your questions, if you didn't submit it anonymously, at least we can reach out to you with answers to those questions. If you did submit a question anonymously and would still like an answer, please reach out either to your advisor or to our team, and we'll get an answer for you. Otherwise, Eric, Khadija, thank you so much. Any closing thoughts as we head off?
I would just say kind of what we've hit on a couple of times now. There's no magic moment. There is no, thing that's going to happen. Work on your estate plan now, get it in place, have it be done, and then move on with your life. Like it's really not that big a deal.
Totally agree. Yeah. Thank you all for joining. And thank you so much for participating and asking questions.